Let's start. The present writ petition has been filed against the said order of the district magistrate seeking quashing of the same as well as the proceeding before the NGT. At the outset, learned counsel for the petitioner submits that despite the availability of an appeal before the Supreme Court under Section 22 of the National Green Tribunal Act 2010 within bracket they are hereafter referred to as the 2010 Act. The said remedy is not an absolute bar to prefer a writ petition before this court. Learned counsel places reliance on a division bench judgment of this court dated November 28, 2022 in WPA within bracket P number 380 of 2022 and WPA within bracket P number 442 of 2022 within bracket Arunabh Ghosh versus the state of West Bengal and others, where a division bench of this court permitted the petitioners to withdraw a public interest litigation challenging a judgment of the NGT with liberty to file proper petition under Article 226 or 227 raising personal grievance before the appropriate bench in the said judgment. The division bench placed reliance on Madhya Pradesh High Court Advocates Bar Association and another versus Union of India and another reported at 2022 SCC online SC 639. In the said judgment, it is argued the Supreme Court categorically laid down that the remedy of district appeal to the Supreme Court from the NGT under Section 22 of the 210 Act is not a bar to a challenge before the High Courts under Article 226 of the Constitution. Para. Learned counsel for the petitioner next argues that the property in question is not a water body and has been marked as bagan, that is orchard in the records of right. Learned counsel places reliance on the photocopies of relevant extracts of records of right annexed to the writ petition to substantiate the same. It is argued that even if the said property was a water body, the NGT would not have jurisdiction to entertain the dispute. Para. Learned counsel places reliance on rules framed under relevant provisions of the Environment Protection Act 1986 for short 1986 Act and in suppression of wetlands within bracket conservation and management rules 210 known as the Wetlands Conservation and Management Rules 2017 within bracket in brief the 2017 rules. Rule 2 within bracket 1 within bracket small g thereof defines wetland to mean an area of marsh, fen, etc. Rule 3, however, provides that the 2017 rules would apply to wetlands or wetland complexes, namely wetlands categorized under Rule 3 within bracket small a and wetlands notified by the central government, state government and union territory administration under Rule 3 within bracket small b. Para. None of the said criteria having been met in the present case, it is argued that the NGT acted palpably without jurisdiction in entertaining the application where the impugned order was passed. Para. Learned counsel next contains that in any event the registrar of deeds cannot be restrained by any order of the NGT from registering documents. It is also argued that the NGT order in fact does not specifically restrict registration at all. Relying on a committee report filed in terms of the order of the NGT annexed to the writ petition, learned counsel contends that there is suggested restraint in the said report regarding registration. Lastly, learned counsel argues that the alleged reliance on the purported Google map by the NGT is misplaced since it is not authentic and does not reflect the correct picture of the location. Learned counsel for the state also submits that section 2 within bracket 1 within bracket small g of the 2017 rules defines wetlands. It is also argued that as per section 2 within bracket small k of the East Kolkata Wetlands within bracket Conservation and Management Act 2006, water body is defined as any land holding water. Heard learned counsel for the parties. The first challenge in the present writ petition is against the memorandum dated April 2023 issued by the Additional District Magistrate MALDA to the District Registrar MALDA, stating that purportedly in compliance with an order dated March 22, 2023 passed by the NGT in OA number 30 /2013 within EZ, the district registrar is requested not to execute any deed as per order and known as Chhatro Bill related to 5 moujas, including the mauja containing the petitioner's property. The order on which the additional district magistrate relies in is also annexed to the writ petition. In the said order dated March 22, 2023, the NGT inter alia constituted a committee comprising of certain experts to visit the Chhatro Bill and inspect the site and submit its report with regard to the alleged encroachments made upon the said water body and to suggest remedial measures for restoration of the said water body to its pristine form, as well as remedial measures to ensure that there is no further encroachment into the water body. The district magistrate Malda was directed in the meantime to ensure that no further encroachment is permitted in the Chhatro Bill during the pendency of the present proceedings. Stop para. Thus, in para 16 of the said judgment, the NGT had directed the district magistrate to ensure that no further encroachment is permitted in the Chhatro Bill during the pendency of the present proceedings. Para. The term encroachment has a physical connotation and means any illegal trespass or entry into a property. Stop. Thank you.